Thank you, Cheryl. Can everyone hear me? I'm wired for sound here, which confirms my worst fear about this meeting. I said, Cheryl, you're not going to record this, are you?
Sorry, see that waiver you signed?
Well, yeah. Thanks for that very kind introduction. I warn you that this will be the least polished of the presentations today. This is not a presentation I've ever given before, and I haven't given it a great deal of thought. I jotted down some notes to myself during two pretty exciting basketball games last night at the bar. And I came up with the PowerPoint literally as other folks were speaking. I thought that would be most appropriate to make sure that I didn't go over ground that's already been gone over. I'm a PhD candidate at the College of Forestry at Oregon State University. My dissertation involves reconstructing climate variability and disturbance variability from tree rings out in eastern Oregon, compiling a record that goes back approximately 700 years or so, and that dominates most of my waking hours. I don't give these issues a ton of thought, but the thinking that I have done in the past couple hours, I'll share with you as follows. I'm probably going to far exceed my mandate that Cheryl gave me. I wanted to frame this discussion with a couple examples of agency discourse that I think are illustrative of some problems in how the Forest Service communicates with the public. And I will diagnose some of these pitfalls in discourse and suggest some strategies for success. Two different strategies, actually. This talk, I decided to call it Strategies for Success. It sounds very like a motivational speaker. I assume that that's really what the agency is interested in, right? Is enjoying more success when it comes to natural resource management. You might think of success differently, but success is one of those things, you know it when you see it, right? And it is what we all want.
Watch your steps there.
I'll try.
The invisible chair.
Okay. So these are two examples of communication from the agency that I have interacted with in the course of my career. It was about a 12-year career being the principal architect of media, litigation, and lobbying strategies for non-governmental organizations. 8 years with the Cascadia Wildlands, who most folks with the Willamette National Forest have heard of. I served as the executive director of Cascadia Wildlands up until, I forget, 2003, 2004, sometime like that. I'd totally forgotten all about the Trapper timber sale, but it's all coming back to me.
It's coming back to us, too.
Well, you all have fun with that. I believe I offered you the opportunity to throw in the towel more than 10 years ago now. So, following the salvage rider, which expired in 1997, the Willamette National Forest began offering dozens of old-growth timber sales in the Middle Fork, what became the Middle Fork Ranger District. And one of the purposes and needs of the projects was to enhance old-growth habitat. And to do this, the Forest Service was going to cut down old-growth habitat. So how does cutting down old-growth habitat enhance old-growth habitat? Well, here's the answer, which you can find in the EAs for timber sales like Simcoe, Happy Bird, Tumblebug, Young'un, et cetera, et cetera. You figure out what like the average size of a patch of old growth in the planting area is. We know that old growth is important for species and size of these patches matter. So if you log, if most of what you're logging is less than that average, then you would increase the average patch size of old growth, thus enhancing old growth habitat. Is everyone following that?
We call those scraps.
I call it chicanery. And I suggest to you that there's something inherently wrong substantively with the message. You do not need to go past the message and interrogate the dialectic between the messenger and the audience, or necessarily consider how you might want to convince an audience that this is true. You might simply want to reconsider the message. This is example number one. I have to note here, if you were to zoom in on one of these old growth patches slated for timber harvest, there's one view from the canopy. So here's my second example of discourse with the Forest Service. I traveled with the Forest Service to a large fire that had burned on the Willamette National Forest, and the Forest Service was proposing to fell out hazard trees along the road, a certain distance from the roadside here, to protect public safety. And many folks along for the ride were deeply suspicious, skeptical of the Forest Service's motives. They thought that it was, just a, what's the word for it? A timber grab, right? An excuse to cut down old growth trees. And a couple folks had fixated on this one old growth tree that was some distance from the road and that people suspected might be somewhat persistent for years and years, i.e. didn't need to be logged. And the argument went back and forth without achieving any particular resolution. I returned to the site several days later on other business, and the tree in question had fallen almost exactly where my truck had been parked the other day. And I thought to myself, well, damn, they weren't bullshitting. Those are some dangerous trees. And in this second example of discourse, I think that we're forced to interrogate a little bit about not just the message, but the audience's motivation and the dialectic between the audience and the messenger. What went wrong that the target of the message was unreceptive? Because clearly the trees were a menace to public safety. So what went wrong? At Oregon State, I teach a class with Norm Johnston called Collaboration and Conflict Resolution. The theory, I think, in having me teach the class was that I tried to explain that I'm not an expert in conflict resolution. I'm an expert in conflict. But I have had some experience in conflict resolution, and I've developed a pretty rigorous syllabus for students, which is built around this wonderful book by Fisher and Urey, Getting to Yes, originally published in 1981. I think the most recent version is published sometime in the 1990s. Has anyone ever read this book? Raise your hand. You ever read Getting to Yes by Fisher and Urey? It really should be required reading for agency types. I don't go in much for this type of, I call it self-help literature, but I think it's a wonderful book. If you haven't read the book, please pick it up. Fisher and Urey present a formula for mutual gains or integrative bargaining, what we've been referring to this afternoon as collaboration. It's a 5-part formula involving interests, inventing options for mutual gain, objective criterion evaluation, the BATNA, and negotiating as if people matter, as if relationships matter. And I want to focus in on that very first part, really the starting place for this collaborative approach. But it's the assumption that people begin with positions, but underlying these positions are interests. And this distinction is important because positions are often mutually exclusive. In dealing with environmental stakeholders, they are, they're again it, right? They might be, they stake out a position which is, it's different than your position. The positions aren't compatible. They can't both be served. But if you dialogue with them and if you dig around into what interests underlie those positions, then you might find that both interests can be served. In the example of roadside salvage I used earlier, the Forest Service's underlying interest was in promoting public safety, while environmental groups' interest was in protecting the environment. Environmentalists' position was that they shouldn't log this old-growth tree. The Forest Service position was that they should. Those positions aren't compatible, but the underlying interest, they could both be served. A funny one I once heard is that doctors have a position about high cholesterol foods like bacon, but a pig has a real interest. So the real critical endeavor and exercise to engage with environmental stakeholders is to try and get at what interests underlie the positions that they stake out. And this involves a lot of listening, active listening, and you can get help with this in the literature and with professionals. But I wanted to try and diagnose what I think is the most common cause of frustration and the failure of the collaborative approach. The failure to identify the interests and be able to work with those interests to invent options for mutual gains. It is when the position itself is the interest. When an abstract concept or idea becomes important, there's a word for it, reification. It's the concretization of abstract conceptual things. People hold on to positions because it is the position. Defending the position is the only real genuine interest that they have. Well, I'll give you some examples. The example that we struggle with over in Eastern Oregon is the 21-inch rule. One of these temporary policy initiatives, now I think 12, 13 years old, which prohibits the Forest Service generally from logging live trees greater than 21 inches in diameter on the assumption that there's not enough large old structure on the landscape. The problem comes in that increasingly many of the ladder fuels like this grand fir that are threatening the resilience of the old-growth ponderosa pine are well in excess of 21 inches. And we have a real hard time getting through to environmental groups who are simply unwilling to part with this position that they want to protect all trees greater than 21 inches in diameter. The position has in fact become their interest. Losing that is what they care about. I was talking briefly with Eric Ornberg over lunch about some of the Willamette National Forest's struggle with species, iconic species like the northern spotted owl, increasingly well-known species like the red tree vole. Conservationists are frequently staking out this position that we cannot do anything to degrade habitat for these species, even in cases, and I can think of a couple cases, where important ecological objectives could be served by management that in the short term would degrade that habitat. It's not that there is this underlying interest in restoring ecological structure, composition, function, et cetera, et cetera. The position is simply that you not degrade wildlife habitat. And there is no real interest underlying that. It has been reified. Is this making sense? People experienced this sensation before that there is no there. There is no way to get past that position and try and serve what surely must be legitimate interests, right? Have you encountered this? Well, I will, as best I can do, present two strategies for getting past this. The first of which hasn't been mentioned yet today, which is you just win. You win the argument. You win the day. I don't remember if it was Douglas MacArthur said, "There is no substitute for victory." Maybe it was Charlie Sheen. I've been involved in, I was trying to do a quick count based on files in my computer, some 95 different lawsuits against the Forest Service, of which, by the way, I won approximately 87%. I used to think that it was a rigged game because of the Forest Service's basic inability to do multiple use management, the inherent contradictions between wildlife protection and economic objectives, as well as some profound asymmetry in decision making between two layers of the federal district court system and the agency itself. I have a lot of complicated theories as to why it was a stacked deck. But I don't believe that it is a stacked deck anymore. I believe that there's at least three things that have profoundly changed the game, having to do with some turnover in the federal court system, new NIFMA regulations, and most of all, a general acceptance among the agency that they should prioritize ecological objectives over economic outcomes. I think, ironically, the Forest Service is in a better position to win in court because they've lost. You can win future battles by virtue of having really lost the war in the last 10 or 15 years. I'll run you through what I think are some important legal history by way of illustrating what I'm talking about. Maybe inspiring you to win the day in the future. Boy, is this really being recorded?
We can redact you if you so wish.
The lodestone of National Environmental Policy Act case law, to me, is the so-called Mapleton lawsuit, actually the real title, National Wildlife Federation v. Forest Service, decided by famous judge Gus Solomon in 1984. Anyone who's worked on the Mapleton district of the Siuslaw National Forest knows the problem with logging on really steep slopes in that terrain, is you get slope failures, landslides. National Wildlife Federation sued the Forest Service over logging on steep slopes in 1984. The Forest Service's argument was that they had protected against landslides by leaving leaf tree areas in the head walls of some of these steep slopes. Judge Solomon ruled against the Forest Service. Why? Because they were wrong, noting that of the 12 headwall leave areas, only 5 had been successful in preventing landslides. In other words, the Forest Service was claiming that these headwall leave areas protected against landslides, even though 7 out of 12 of them had experienced landslides. It's what they call an open and shut case. The Forest Service is just wrong in a pretty obvious way, and simply asserting that they're right was not enough to win the day in court. To my mind, this litigation thread really spiraled out of control from in the 1990s, when the Forest Service was saddled with a number of procedural and substantive requirements that were not necessarily explicit in the laws and regulations, particularly this site-specific survey requirement. In Lands Council v. Powell, the Forest Service wrote an EA proposing extensive logging on a burned area. They made assumptions about impacts to soils without relying on any data collection in the actual area where the logging was to take place, i.e. they extrapolated what they knew about soils in a different area to this area. The court ruled that you can't do that. If you want to make assertions about impacts to soils, you have to sample the soils in the area. And this is fascinating. I mean, there's a requirement in NIFMA to protect soils, but there's nothing in the regulations that says thou shalt, take site-specific data from where you want to log to. In another lawsuit that quickly followed Ecology Center v. Austin, the site-specific analysis requirement was extended to wildlife, specifically this guy, the black-backed woodpecker. The Forest Service was required to, survey within the planning area itself in order to rationalize its conclusion that there wasn't going to be any impact to this guy. And the court has really done the Ninth Circuit Court of Appeals has, to me, really done a 180-degree turn from this. In Lands Council v. McNair, I had the opportunity to meet with Forest Supervisor McNair up in her office in northern Idaho. Lovely woman. At issue in Lands Council v. McNair was the flammulated owl. This guy here. The Forest Service wants to do all this fuel reduction logging in the ponderosa pine type where there's concerns about viability of the flammulated owl. And understanding this site-specific survey requirement, the Forest Service sent their biologists out to look for flammulated owls within the planning area and within areas that had already been treated within the planning area. So he's out there every night hooting for flammulated owls. And after about a month of this, he detects one flammulated owl, lo and behold, in an area that had already been treated. So this gets written up into the EA. I'm sure you can imagine, there's not impacts to flammulated owls from fuel reduction logging because we found a flammulated owl in this area that had been so treated. The judge, Ninth Circuit Court of Appeals, rejects this argument, and I should be able to draw on the board here, but what's the problem? What's the problem with the Forest Service's position here?
There's only one owl.
In statistical terms, n equals 1. You could graph owl presence and logging, and it would be just like that one data point. It's not a trend. Yeah. The court, in a remarkable maneuver, reconsiders its own judgment all Ninth Circuit cases are decided by a panel of 3 judges. In this en banc proceeding, the Ninth Circuit reheard the case with a larger panel of 13 judges and threw out their own decision, re-emphasizing that review about whether these decisions are arbitrary and capricious is based on really just 3 things. Whether the agency relied on factors Congress did not intend it to consider, whether they entirely failed to consider an important aspect of the problem, or offered an explanation that runs counter to the evidence before the agency, or is so implausible that it could not be ascribed to a difference in view or the product of agency expertise. You can tell why I started with the Mapleton lawsuit, right? Agency decision-making under this legal framework is wrong and bad and should be thrown out basically when it's wrong. Agency decision-making should not be thrown out because scientists differ or information or the agency picks and chooses from among the information that's available to it. It can only really be thrown out when the decision-making just cannot square with the facts at all, when it's entirely implausible. And the court reminded plaintiffs that in recent years, our environmental jurisprudence has at times shifted away from the appropriate standard of review, which is above, and could be read to suggest that this court should act as a panel of scientists. I don't believe that the Ninth Circuit Court of Appeals is presently willing to second-guess reasonably constructed arguments made by the Forest Service about environmental impacts. If you were to try and protect against landslides by leaving leave areas that didn't work, then you would be in hot water. If you were going to log in spotted owl habitat and assert that there would be no long-term impacts to spotted owls and back that up with a reasonable argument, I think that the court at this point is prepared to defer to your judgment. Recently, the Willamette National Forest had either a minor or a major setback with respect to the goose timber sale, where the issue was whether or not the Forest Service had prepared basically the right document, whether significant impacts, whether there was the potential for significant impacts because of the location of the sale and at least partially in a roadless area and treatments in riparian areas, et cetera, et cetera. It's sort of a separate issue, which I think has a pretty strong chance of being overturned by the Ninth Circuit. But I hope that that's, if not guidance, then a little bit of inspiration about how to win the argument. The second strategy for success that I mentioned was the collaborative approach. I've been deeply involved with the Blue Mountain Forest Partners collaborative group. I helped get the collaborative off the ground 8 years ago now. Here's a picture of us in a recently completed fuel reduction thinning operation on the Malheur National Forest. We've gone through 4 different projects now that have treated close to 2,500 acres, which is modest compared to the need that's out there in terms of fuel reduction thinning. But I regard it as a highly successful collaborative, and I'll suggest at least 3 ways that I think that you could overcome this problem of reification where there is no real concrete interest that underlies the position that gets staked out. The first is simply putting people with divergent point of views in close proximity to one another. It's really easy for positions to be entrenched at a distance, right? You can engage in a pissing match through the media, but when you bring people with divergent ideas together in one room, a lot of the bullshit tends to dissipate, right? Proximity to people with whom you disagree does not resolve conflict. It could even sharpen conflict to a certain degree, but it forces people to talk about and listen to, what are the underlying interests involved here. Proximity is a way to get beyond positional bargaining. It's real important to get into the field, right? Everyone who's done a lot of field trips with stakeholders knows that, again, it's harder to disagree when you have what you're talking about right there in front of you. My final and last piece of advice, which I'll conclude with, and I'll take some questions, comes from James Madison, the grand strategist of the American system of governance, who suggested that government extend the sphere, take in a greater variety of parties and interests, making it less probable the majority of the whole will have a common motive to invade the rights of other citizens. Does anyone ever feel like the Forest Service in some ways in recent years has experienced this bizarre form of a Stockholm syndrome? It's not that you are a hostage to the timber industry or to the environmental community. It's a lot worse than that. You're hostage to both of them, right? It's the nature of the pluralistic system of governance in this country that this quiet majority, what were we calling it? The silent, well, I think it was Richard Nixon that referenced a silent majority, the invisible middle. To the extent that there is an invisible middle that cares about natural resource management and can act decisively with respect to natural resource management, I'm very skeptical that such a group of people really exists. But to the extent that it does exist, it's powerless to act because power in this country is operationalized through interest groups. And the Forest Service is very much held hostage to two different interest groups who engage in this mental process of reification as a matter of course. And there's no check on them doing this because they are not typically in proximity to other interests. And I would suggest to you that the major strategy for success for the Willamette National Forest moving forward is to extend the sphere and make the work that you do relevant to a larger group of people and create constituencies, clients, among a much larger set of interests than simply the timber industry or the environmental community. To force both the timber industry and the environmental community to confront this process of reification that they're engaged in and be able to articulate what real interests underlie their positions. Because other interest groups do have genuine interests. They don't have positions about natural resource management that they are slaves to and that they're going to make you slaves to. And we could spend a couple minutes trying to brainstorm who some of those folks are. Does anyone know, for instance, who the largest employer in Lane County is?
U of O? Government.
Nope. I'll give you a hint. It's the same industry that's the largest employer in Douglas County, in Josephine County, in almost every natural resource dependent county in eastern Oregon. No, it's the regional hospital. Peace Health is the largest employer in Lane County. Is there an intersection between the needs of the healthcare community and the national forest? I'd suggest there is. The Willamette National Forest is engaged in what seems like a pretty fruitful and productive collaboration with the large Eugene public utility, EWEB, which depends on the water from the national forest. This is a classic example of an organization that has a real interest in environmental protection that is not as likely to be stated in this positional way. Somebody mentioned the University of Oregon. Does the University of Oregon have a stake in the management of the Willamette National Forest? It really should. It really should. And I would submit that the Willamette National Forest has a real interest in collaborating with the University of Oregon and other organizations like it. I hope that this presentation hasn't been too incoherent. Like I said, it's the first time for me. I often use these. This is my field crew. These are my two dogs. This is Zella, and this is Rhoda, and they are a model of how to get along. And this is, they're best friends. You've never met two dogs that get along better. And here's the secret. Zella is Rhoda's favorite dog, and Zella is Zella's favorite dog. I think that has some relevance, but I'll let you think about it. Any questions or comments?
Yeah. So I have a comment. Your observation at the end about the hospitals being the largest employer in the county. I have a scientist on my team who studies health benefits of trees, and he's very good at it. There's a lot of publications. And he's arguing basically that we need to move towards an understanding of forest as part of our cities, but also national health infrastructure. And you wouldn't believe the grief he gets in Washington, D.C. about the research he does, because it's so out there, and it's so different from traditional research. And about once every other year I get called into meetings, Sarah, Jeff has done it again. You know, how are we going to rewrite this news release so it doesn't sound weird? But it's just brilliant. And it's exactly what it's done.
The challenge for major institutions like the University of Oregon and the hospital is a people challenge. It's attracting the best and the brightest people. And the comparative advantage that Eugene has over any other, over Sacramento, is what? It's in large part the landscape encompassed by the Willamette National Forest, I would argue. I mean, what is the difference between Sacramento and Eugene?
We're not in the valley.
Livability.
Yeah.
Shire.
Other questions? Thank you, James.
Thank you.